Praise the Lord. I was turning to the terms of the 1974 case.
Yes.
Before dealing with the carve-out clause, I will briefly
I'm terribly sorry, Mr. Holland. You have to speak up because I've got some helicopter, I think, in my ear.
I'm not normally accused of speaking softly, but
no, it's the combination of.
I'm sorry.
Thank you.
I'll deal with a quick skirt through the other clauses in the 1974, at least before concentrating on what we've called the carve-out clause. It's the same as I point out, it's exactly the same lessees, lessors rather, as in the 1974 lease, grants for a substantial premium. There's a surrender of the former lease of the premises, as you see by halfway down the page. There's an express right granted to pass and repass, with or without vehicles, over that part of the roadway commonly in here and after called Sheldrake Place. Express right granted. There is a reservation to the lessors of the free running of water, soil, gas, electricity coming from any building. So the same reservation as we see in the 1969 head lease. And you must assume, therefore, that the parties were aware of any drains, pipes, cables, etc. There is a reservation of all other easements, quasi-easements and rights belonging to or joined by or adjoining neighbouring premises. There is an exception in the middle of the phrase, a reservation, without obtaining any consent, to build upon any adjoining or neighbouring land forming part of the firm or state, aforesaid persons, and that's to do with the right of light, as shall be proved as notwithstanding any interference thereby occasioned to the access of light or air. So authorities would show that that is clearly intended to reserve a right to construct in respect, notwithstanding any interference with light or air. But my point is that if that is a relatively narrow exception intended to prevent any rights to light or right to air preventing construction, then the carve-out clause itself must be a different meaning. It must be a wider meaning, we would submit. And then, again, about page 107, there's the addendum, and then there is subject also to all rights and easements or reputed or quasi-easements appertaining to any of the adjoining and neighbouring properties. And then we come to the carve-out clause itself. Of course, there is no express right granted, which is the equivalent to the reservation of that we see in respect of the free running of water, soil, and gas. Now, there's a number of points, or 2 points. First of all, if you look at the words that I just highlighted, talking about soil, gas, electricity, etc., and then the words of the carve-out clause, which especially refers to waste, watercourses, sewers, drains, lights, buildings. As I say, the parties to the 74 lease were well aware of the existence or possible existence of sewers, drains, lights, etc. They had that well in mind. There's an express reservation of the landlord, and the carve-out clause expressly refers to it. Secondly, if you look at the clauses we just looked at, and then compare them to section 62.2, the words are virtually recited. The parties were well aware of section 62.2 and its possible effect. I mean, the words in the carve-out clauses, watercourses, sewers, drains, lights, liberties, privileges, assessment, rights, or advantages whatsoever, are a direct lift from section 62.2. And although it's not in the carve-out clause, there's express reference to easements and quasi-easements, page 117. And at the top, a third of the way down, and then a further reference under the addendum, 91 years, subject also to all rights, easements, or reputed replacements appertaining to any of the adjoining premises. So appertaining is again picking up, we would say, section 62. So the parties were clearly aware of the potential effect of section 62. And the carve-out clause itself, as already pointed out, is the boilerplate clause. It is not the same as the 1969 case. It is the boilerplate clause with the words except those now subsisting added immediately before the disjunctive or. And we would submit that the natural reading of the clause is exactly how both judges below read it. You need to read it a few times, but it's clear, we say. It divides into two separate or distinct operative parts or limbs. Or there's an exclusion, and then there are two operative limbs which qualify that exclusion. We've set out how it should be read at paragraph 12 of our skeleton, and I think the judge did that himself at it's paragraph 85 of judgment. The carve-out clause is clearly not intended, and we submit it doesn't. It doesn't affect express rights granted in the by the 1974 lease itself. The introductory words of the clause. Demise hereby shall not be deemed to include and shall not operate to demise, make it clear that, for example, it doesn't affect the expressly granted right of way. Secondly, I say it divides into two parts. There is the general exclusion, and then there is except those now subsisting, and then there is the disjunctive or, which might restrict or precondition of execution. And we know now, originally my learned friend's submission to the judge of first instance was that the word or was a mistake. And we now know that that's not right because the evidence he's filed to get a second appeal proves that the boilerplate, or every single clause, contains that disjunctive or. So he can't make that submission now on his own evidence. But what he now says is, aha, the boilerplate clause is thrown into confusion by the insertion of the words except now subsisting. And his original submission to the judge was you delete the word or. He now submits to you, you leave the word or, but you shift the words except those now subsisting. And we say that's doing damage to the wording of the clause. The party we would submit that both the disjunctive or and the placing of the words except those now subsisting are entirely deliberate. They were the result of the negotiations between two commercial entities who entered into this lease. And had they wanted or intended the words except those subsisting to go at the beginning or the end, they would have done so, as was negotiated in the 1969 head lease, because that's where the words are inserted there. But they didn't. They put them there, and we would submit that's entirely deliberate. And to use the words except those subsisting, effectively to put them at the beginning or the end, is to do damage to the clause, and very significantly to affect its meaning. And we would submit that in those circumstances, the clause has, as intended to have, a very wide ambit. As I've submitted, it is in addition to the specific clause back over the page which deals with rights to light, so it must be dealing with something more and wider. And we analyse it in paragraph 18 of our skeleton. Firstly, what is excluded? That is, demise hereby made shall not be deemed to operate to demise any ways, watercourses, sewers, drains, lights, liberties, privileges, easements, rights, or advantages whatsoever. That is the widest possible exclusion. A number of points. One, it expressly excludes watercourses, sewers, drains, and lights. That's the other point sensible to the fact that you may be excluding the right to run drains, sewers, etc. Secondly, as I've said, it echoes the words of section 62.2. And thirdly, it catches the right to park as pleaded and found by the judge. On the learned friend's case, as at the date of the 90 or just before the 1974 lease, the right to park was a legal right reserved to the landlord, that's the Phillimore estate, under the 1969 head lease. It was not a right which was then enjoyed by the occupiers of Duchess of Bedford House under the 1938 head lease. It was a right sort of floating in the ether, which by, unless it's excluded, would be granted and thus form a right by the 1974 lease. So in my submission, my learned friend makes the point it's not wide enough to, it's not express enough to exclude. It clearly is. This clause is intended in the widest ambit, and if my learned friend is right in that part of his case, that the 1969 head lease reserved the right to park, it was a right. That's what he says in the skeleton, that's what is pleaded, and therefore it would be excluded as a right under the carve-out clause, unless it falls within either of the two exceptions. The word used is might. I'll come back to that, but it's an ordinary English word. It's not will or would or is likely to, it's might. The words used are restrict or prejudicially affect. Those again are very wide. It's not prevent, it's restrict or prejudicially affect. Again, very wide. And the activities which it contemplates, the future rebuilding, alteration or development or redevelopment thereof, again, are very wide. And it looks at the future. And we would submit the point is to prevent the transmission of unexpressed rights which might restrict or hinder development in the future, the nature of which development cannot at the date of the lease be foreseen.
How does the disjunctive or work if you don't have the exception? In looking at this, the way I'm looking at your skeleton, the way you've split out the
Yes.
and I'm imagining the words except those now subsisting as not being.
Yeah.
So that it says, demise shall not be deemed to include and shall not operate to demise any drains, etc. That's my
Yes.
the point you made. 1, in, through, over, upon any land of the lessors, dum-de-dum.
Yes.
And then on your case, the or is a disjunctive or.
Yes.
And which might restrict, but those two clauses are characterising things in a different way from each other. They don't operate disjunctively.
Well, they operate separately in the sense that, for example, it's what's excluded are A, the activities, ways, watercourse, sewers, drains, lights, privilege, right settlement. 1, in, through, over, or upon any land of lessors or forming part of Phillimore Kensington estate, aforesaid. Yes. So that's 1. That's a physical manifestation.
What other rights could there be?
Well, there might be rights over third-party land which isn't within the estate.
Right.
Because this is a lease of 91 years. It's certainly over 90 years. And it might be possible that the Phillimore estate either purchases other land or enters into a development agreement with a landowner of land next door, which isn't part of the estate or wasn't at that time. And it's tended to exclude that. It's a catch-all, I accept. And it may be difficult to envisage certain that, but there are circumstances which it might.
Okay.
And that's the, I'm looking at the boilerplate clause, which is at page 103, divider 11 of the supplemental bundle. That's the
Speaking for myself, for looking at this as at 1974, and imagining it obviously applies at 1974.
Yes, it does.
Acts.
Yes,
it acts at that point in time. What happens after that doesn't have anything to do with it. As far as I can see, the only things which might be rights which restrict or prejudicially affect the future building will be rights in, through, over, or under the land of the lessors, etc.
Well,
which is the point I'm asking about, because that means that this or isn't quite as simple as an or as to call it a disjunctive or.
Yeah, well, in the 19th, it may be that as a result of the amendment, it is.
Well, that may be.
That wasn't
the point you were making.
Well, it occurs in every single clause.
Mm-hmm.
and it clearly we would submit qualifies or is a further. It adds a further.
No, I understand. I understand how.
It distinguishes
Don,
between.
just to be clear, I
Yeah.
get the point that as written, as it is,
Yes.
I can see how you
Yeah.
can make the or a disjunctive or, because those two clauses then don't overlap with each other in a simple
Yeah.
way, and you can say that one or other of them can apply, and they both do work.
Yes.
But what wasn't the question I asked you.
No. I'm sorry I didn't
That's all
answer
right.
it.
No, you did. That's fine. Thank you.
No.
I don't
But
want to waste time.
no. I could see that, but the point I'm trying to make is that if you look at the unamended clause, which says 103, the words which follow the or which might restrict, must add to the words which precede it. So what is being, and it's intended to be as wide as possible, and one must realise this is the Phillimore estate. It's not just a landlord which owns a particular building. This is a lessor which owns large tracts of land in the vicinity and still owns. And yes, it may be that as originally unamended, the words following or, which might restrict, add little, because you've already had a very large carve out in the first part of the clause, which refers to the Phillimore estate, Kensington estate aforesaid. Yeah. You're just adding, oh, and by the way, any rights which might restrict development. But there are circumstances where that clause might bite if there was land which was not then part of the Phillimore estate, and in respect of which, for example, the Phillimore estate either acquired subsequently or wanted to develop or deal with in the vicinity. That's the point. It may mean little if you're talking about a normal landlord who owns an individual building in London, or in a street. But when you're dealing with a landed estate such as the Phillimore estate, it makes more sense. Okay. But my lord is right in the sense that once you have the word except those not subsisting, we say you clearly get a disjunctive or the meaning of the or is emphasised. And we say if it's construed as the judge did and as we say it should be, then it is clearly wide enough to exclude the right to park. And we say the judge was right to find that it did by reference to the examples. Now, these examples of parking arose, I mean, the original reason for calling the evidence of parking was to show that there was no parking to meet the factual case. The judge tried to dismiss that, but then the case was made, well, Mr. Holland, how does this clause operate? The judge, His Honour Judge Gerald, found, of course, we've got a right of way. Surely that's enough. You can't exclude anything. The right to park adds nothing to the right of way, so you can't say it falls within the second limb of the clause. And I came up with 3 examples as to how it would, how developments or activities on Campden Hill Gate, which would not interfere with the right of way, would nevertheless be curtailed by the right to park. And one of them was, as we said, look, the example that you see, which was contemporaneous at the time. Here was an attempt by the owners of Campden Hill Gate to restrict parking, to control the parking, they would say. And that itself would affect the right to park, but not affect the right of way, because it was proposed that there would be a one-way system and the 12 lockable bays. Now, even if there was no restriction on the number of parking bays, the installation of lockable bays would restrict the right to park, because what you've got then, what they got at the minute, was a free-for-all. Anybody could park there without restriction. The point of installing the lockable bays was to let them out, and that's clear. You looked at the correspondence, we've quoted it at some length, we got a schedule of it, but it's quite clear, one, that residents continuously complained that the result of the proposal would be to restrict the number of parking spaces, i.e. the right to park, and that it would restrict it by allowing the landlord to install the lockable bays and charge for the use of those bays. So that was, as an example, you say it's commercially absurd, my construction. Well, look, here is, you don't have to think very hard of an example whereby the right to park would fall within the second limb, whereas the right of way wouldn't, or the right of way wouldn't. Because that's the judge's point. He made wrongly, we say, well, you've got a right of way, therefore the right to park has nothing. if you look at it, my learned friend went into some detail about it, as have we, but it's only an example. It's a point of contractual construction, but it's to meet the point made to me that the right to park cannot fall within the second limb because it adds nothing in that effect to the right of way. And that's nonsense, we say. I mean, if you look at what was actually proposed, it was 12 lockable diagonal bays and no parking down the eastern flank. That's the point. If I can take you to, I'll give you the reference to that. If you go to the supplemental bundle, divider 10, page 99,
no.
and this is the inspector's decision, paragraph 7. Furthermore, I'm not convinced the provision of angled parking bays leading as it would to the loss of valuable amenities is the best way of achieving a more orderly system of parking at the site. While your client's proposals would, under normal circumstances, provide a wider passage for vehicles than that available from the present system of haphazard parking on both sides of the carriageway at Sheldrake Place, this passage would nevertheless become severely, if not completely, obstructed by a single vehicle stopping on the opposite side of the bays. So it's clear that the proposal, and my learned friend has taken you to the diagram which was proposed. It's divider 4, page 23. The proposal was to have parking solely down the eastern side and no parking along the western side and no parking on the eastern side. That's the inspector's report. So that is how it would have restricted the parking. And don't rely on me on that. Rely upon the contemporaneous comments of the various residents of Duchess of Bedford House and Campden Hill Gate and Duchess of Bedford House that we have quoted in our schedule, and the comments of which you see in the supplemental bundle. And again, the point I'm trying to make is simply that it is easily, if you're thinking about whether the right to park falls within the second limb, it's not very difficult to come up with examples of developments, amendments, constructions which would not interfere with the right of way, but would interfere with the right to park, or which would prevent by the right to park. And that is reducing the number of parking bays and also charging for them, restricting their user to those who are charged. Now, another example I gave to the judge is the construction of garages. And again, if one looks at the further supplemental bundle, at page 32, this is the other little bundle. I've already referred to this document because I refer to it.
Sorry,
It's the further supplemental bundle. Little one is divider 5, page 32. And this is the local planning authorities, the London City of Westminster's comment on the appeal to the planning inspector, which eventually dismissed. And statement. Initial development plan. This estate develops within an area located in residential planning history. Duchess of Bedford House, followed by the two blocks, Campden Hill Gate and the layout of Sheldrake Place, were approved by the former LCC in 1933 and built shortly after. There were no particular conditions for Sheldrake Place. In 1954, the LCC granted permission for 36 lock-up garages with a store and 2 self-contained flats off Sheldrake Place. That's off Sheldrake Place North. In 1957, the LCC granted permission for the erection of 2 pairs of semi-detached houses on Sheldrake Place, frontage to the north of the estate. In 1957, permission was granted for a block of 3 lock-up garages north of Duchess of Bedford House and 2 lock-up garages off Sheldrake Place. Now, it's clear that since the original construction of both properties, there had been further construction of garages off Sheldrake Place. Now, suppose the owners of Campden Hill Gate had proposed to put garages down the eastern side of Sheldrake Place East, or the western side of Sheldrake Place East. Now that would have interfered with the right to park, because you couldn't have parking in front of the garages because they couldn't get in and out. It would certainly not have affected the right of way. So again, another example I gave to the judge, I think I mentioned it to the appeal judge, whereby you didn't have to think very hard of an example whereby the right of way would not be interfered with, but a right to park would be. I also gave the example to the judge of perhaps a construction of buildings, further buildings right up to the edge of the carriageway in Sheldrake Place East, which might interfere with the right to park by maybe you couldn't get out on that side of the road, but which would not affect the right of way. And it's simply to meet the assertion that by the judge that you've got a right of way, the trial judge, you've got a right of way, how does the right to park interfere with that? And we say the second falls within the second limb, and it's by no means unforeseeable. It's quite possible. It's really possible. You can say, possibility is it's possible that those in the future, during the 91 years of this lease, further development would take place on Campden Hill Gate, which would be hindered, the words again, which might be restricted or prejudicially affected by the right to park. And one of my learned friends points, he says, well, it's not a realistic possibility because the trustees of Phillimore Estate, there's no, under the 1969 head lease, the lessee cannot make amendments or alterations without the consent of the Phillimore Estate. And the Phillimore Estate, in deciding whether or not to grant consent, can take into account the interests of Duchess of Bedford House. Well, so they can. But there's a number of points on that. First of all, you're not, if you look at the carve-out clause, it's concentrating on the nature of any future development. It's not concentrating on the possibility or the likelihood of that taking place. It's which might restrict or prejudicially affect the future rebuilding, alteration, or development or redevelopment thereof of any other adjoining property. So the likelihood of any development is irrelevant. It's simply that if you postulate that there is some development, whether it's likely to occur or not, then you analyse the clause on the basis of, well, would that right, might it interfere with it? So the likelihood or not is irrelevant. And secondly, we would submit that all the more reason for the Phillimore Estate to exclude the right to park. Remember, the Phillimore Estate was the lessor under the neighbouring premises under the 1969 head lease. It had control over what went on there to an extent because the lessee, under the lease, couldn't make alterations or without its consent. Now, it couldn't unreasonably refuse consent, but it could reasonably refuse consent. Now, it might, as a landlord of the various parts of the area, want to maintain control. Suppose, for example, the lessee under the 1969 head lease had come to the estate and said, well, look, we'd like to erect some garages down the western side of Sheldrake Place East. We require your consent to do so. And the lessor might want to control that, might say, well, all right, I'll allow you, but you'll have to pay me more rent. Or I'll allow you, but I don't like the look of those garages. I'm concerned about the aesthetics of the estate. You'll have to change them. That would give the Phillimore Estate control over what went on Campden Hill Gate. However, if there was a right to park along Sheldrake Place East, that control is taken out of the hands of the Phillimore Estate and given to the lessees or the occupiers of Duchess of Bedford House next door. Because on the garage example, the owner of Campden Hill Gate comes to the Phillimore Estate and says, I'd like to erect some garages. Yes, we'd love to allow you to erect some garages, but I'm afraid there's a right to park in the hands of the residents of Duchess of Bedford House next door, and we'd love to, but you can't because it'll interfere with their right to park. So I'd turn that on its head, and the fact that the lessor can consent or not reasonably refuse consent gives it the control that it wants. And thirdly, simply because the owner, the lessee, the lessor rather, the trustees, can control development by withholding or granting consent doesn't mean that they won't. We know under the previous lease, the garages were erected. So it's perfectly foreseeable that even if you want to erect locked parking bays, and there's no intimation that the trustees objected to that proposal. But suppose you want to erect garages. There's no reason to suppose that even though their consent was required, the trustees over the term of the 91-year lease might not grant it. So the fact that there is control under the 1969 head lease and restriction is not doesn't stand in the way of how we say this clause should be construed. And we say the judge was entirely right to overturn the first instance judge and say as a matter of construction he was wrong. And I now come to what I had understood as, I think, Milady had understood my learned friend's point about on ground 3. It is said, as I understand it, that even if he's wrong on everything else, His Honour Judge Gerald, in deciding that the right to park didn't fall within the second limb, was coming to an evaluative judgment which the appeal court shouldn't interfere. That's nonsense. It's a question of contractual construction. The law, actually, I think, is set out. If you go to page 204 of the budget, this is my learned friend's Figure 12, page 204. And this is my learned friend's skeleton argument to the appeal judge on my appeal on the question of fact. But he cites the various judges, Steichen, it's paragraph 48, Lewis and L. J., who again was citing his own judgment in the Faget case. And this is the law on what appellate courts and why they're reluctant to interview findings of fact. Appellate courts have repeatedly warned by recent cases at the highest level not to interfere with findings of fact by trial judges unless compelled to do so. This applies not only to findings of primary fact, but also to the evaluation of those facts and to inferences to be drawn from them. And then he sets out the reasons. Now, this is not an evaluation by His Honour Judge Gerald of any primary facts that he has found. He made no findings of fact. It's a question of contractual construction that he was faced with. It's a question of law. Contractual constructions are questions of law. The extract from, I think it's Lewison, Lord Justice Lewison's book says, questions of construction are questions of law, the meaning of words are questions of fact. But the judge didn't find the meaning word. He heard no evidence on the meaning of any particular word. He had to construe the contract. And that's what he did. We say he was wrong. But the fact that he might have found or held, because he didn't find anything, that the right to park would not interfere, or didn't fall within the second limb because it wouldn't interfere in the way that I say, it's not an evaluative judgment in the sense of the Faget case. That's right, I found the primary fact. I had this against me, a case called Hirose and Peak, it's nuisance. The judge found a primary fact. He heard evidence, heard expert evidence, he had a site visit, and found against my client that there was no nuisance in a particular case. I appealed to the Court of Appeal, was told, sorry, it's an evaluative finding, as in, it's the Biogen case, Lord Hoffman's well statement there. That's what it is. Now, that's an evaluative judgment based on findings of primary fact. But that's not what His Honour Judge Gerald was doing in this case. He was purely dealing with a matter of construction. There's no evaluation on facts. There's no evidentiary burden on parties in respect of questions of construction. Again, if you want, that's Lord Justice Lewison's book at paragraph 4.08. But even if it was an evaluative judgment, which falls within the Faget principle, we would submit that the judge was right to overturn it because it's infected with mistakes of law. First of all, he has impliedly found that the word might in this clause is restricted to, I think, go back to his judgment. It's right judgment is paragraph 89 at page 255. My judgment is that says such must be grounded in reality. So he impliedly has restricted the meaning of the word might in this clause to possibilities that are grounded in reality and are not, in this first sentence, ingenious and perhaps extravagant suggestions. That's what he called my submissions. So that's what he's done, and that's a question of law, and that's the basis of all this, and that he's wrong on that. And it's a matter of construction. The appeal judge was entitled to come to a different view. Secondly, if you look at paragraph 88, he says this, and again, this is page 254. My judgment, the simple answer to that equals this, 87. The question, therefore, is whether or not the right to park on either side of Sheldrake Place East, which itself has been delegated by the express granted right way thereover, could, in any practical sense, be free of prejudicial effect to future rebuilding, alteration, development, or redevelopment of any other property adjoining Sheldrake Place East. In my judgment, the simple answer to that is no, because a right of way has been granted over the whole of Sheldrake Place East, by virtue of which, for all practical purposes, Sheldrake East cannot be materially altered or developed. But that's it's a too narrow concentration of the right. What he said there is Sheldrake Place East can't be developed because of the right of way, but the clause applies not just to Sheldrake Place East, but to all neighbouring land. And therefore, if the right to park would interfere with development of neighbouring land, i.e. land adjacent to Sheldrake Place East, then the second limb would apply. So the judge got it wrong by simply concentrating purely on Sheldrake Place East. And again, he makes the same mistake, or an allied mistake in paragraph 89 in his last sentence. I can see no basis for suggesting or finding that the existence of the parking rights would prevent any alterations or whatever to Sheldrake Place East. And again, he's concentrating very much on Sheldrake Place East and not on the wider surrounding area, which is what the clause applies. It applies to Sheldrake Place East as well, but he's concentrating very much on
I understand. I mean, I see the point you're making. That the judgment here is focused on Sheldrake Place East, and you're right. You're perfectly entitled to make the point. The clause is wider than that. If it's right about Sheldrake Place East, doesn't it follow it's right about everywhere else as well?
No, that's the example as I'm saying. Look, suppose you can't touch, and I'll come back to this when I come to Miller and Friends' submission on absurdity of business common sense, hopefully very shortly. But suppose you can't touch Sheldrake Place East, right? You can't. Well, you can't interfere with the right of way. The right of way is expressly granted.
No. My question is whether if this is right. I understand. That's the point of my question.
Yes.
Because if this is wrong, you win on the point you're arguing.
Yes.
So it doesn't matter. My point of my question is whether your submission makes any difference. Because if you're wrong about this point about Sheldrake East, at the moment it's not clear to me how the reference to other land helps you.
Well, maybe I don't understand your question. I'm sorry.
Don't worry,
it's
move
my
on,
fault.
Mr.
No, it's my fault.
My question.
I mean, the point is, the clause applies, the carve-out clause applies to Sheldrake Place East as well as it applies, for example, to Campden Hill Gate or any other surrounding land. And the judge's point was, well, there's an express right of way granted over Sheldrake Place, so you can't touch that. I mean, he may be wrong on that because it's substantial interference with the right of way. So you could, for example, build over a part of Sheldrake Place East and not interfere with the right of way because you haven't substantially interfered. It's the B&Q Liverpool test. Interference with the right of way has to be substantial interference. Therefore, if, for example, Campden Hill Gate built 6 inches into the carriageway of Sheldrake Place East, that wouldn't necessarily be an interference with the right of way. I'm struggling to come to
I don't want to take time. Don't worry.
all right, but
Don't worry.
and the other point I make is that even if His Honour Judge Gerald is right, that you have to concentrate on what is grounded in reality, practically realistic. My submission is the examples I've given are forward in that, and he's simply wrong to dismiss them, and it's not an evaluative finding of fact. can I briefly deal with business common sense? Because that appears to be the linchpin of my learned friend's point. We say there's nothing remotely contrary to business common sense to interpret the carve-out clause as the judge did. Indeed, it's entirely in keeping with that. The appeal judge was entirely correct to consider that a landed estate such as the Villamore estate would have wanted not only to prevent the conversion of informal and de facto practices into legal rights, but also to have left itself with maximum flexibility to deal with the surrounding land over the term of the 1974 lease, and that applies whether the surrounding land was let, as Campden Hill Gate was. Indeed, it might more narrowly have been in the Villamore estate's interest to prevent private utility infrastructure being constructed under Sheldrake Place East. Because if it's public infrastructure, there's maps of that, you know where it is, but if there's a private pipe and you want at some stage to dig it up for various reasons, you might not know where that was. But I submit that my learned friend is wrong to say that the construction of the second limb, as the judge renders the first limb, nugatory. If he's right, take this example. Suppose there is a sewer, a water main running down the middle of Sheldrake Place East. And suppose there is a spur to that, leading off to Duchess of Bedford House with a meter. And suppose there is a private pipe running from Duchess of Bedford House, at least partially under Sheldrake Place East, to the meter. Now, and suppose that right has arisen under the 1938 lease by reason of section 32, or section 62. Now, the water main and the spur will be owned by the public, it was at that stage of public utility, because we're pre-privatisation. So it won't be owned by the Duchess of Bedford House residents, and they have no need for a right because it'll be there pursuant to statutory powers. And suppose the private right, if you look at the private pipe, it won't fall within the second limb. Suppose it falls within the first limb, that is, it's a subsisting right. It won't fall within the second limb. Both because, if, for example, take my learned friend's underground car park example. One, that will interfere or potentially interfere with the expressly granted right of way. But more importantly, it will be prevented by the right of the public utility to run the sewer under the land. So the private pipe will add nothing. It won't fall within the second limb because any development will have been prevented quite separately by the right of way and the existence of the public utility. So it's not rendered nugatory at all. If you take that example, if you concentrate on that example, even if there is a private pipe running or a private cable or a private sewer, it is running to a public utility. And in order to construct, or in order to build on or over or under Sheldrake Place East, Campden Hill Gate would have to both interfere with the right of way and interfere with the statutory right of the public utility to run its sewer, its cables, or its water main underneath the road. So it's perfectly possible, and again, we're dealing with business common sense here, to envisage a situation whereby you do have a private cable or pipe or sewer under part of Sheldrake Place East. But that does not fall within the second limb because it doesn't separately interfere. It wouldn't. Again, I go back to the days of
restrict or prejudicially affect.
It wouldn't restrict or prejudicially affect the future construction. So it's not rendered nugatory. And with respect, the appeal judge is entirely right, we say, in those paragraphs that the learned friend took you to say that it's perfectly coherent and rational for a landlord to have the restrictions in the way the judge, or to insert restrictions in the way the judge construed them into a lease of this type. It's very common. And it's not pure speculation. I take Milady just Asplin's point, and we agree with it. I mean, it's not a judge comes to commercial common sense. There's no evidence called us to commercial common sense. It's not pure speculation. It's the judge's application of commercial common sense. We also add, in respect of those points of services, a number of points in paragraphs 42 to 46 of our skeleton. Because I concentrate on that because that's the point very much Milady Friend makes as to why it doesn't make business common sense. And there's not, you said there's no evidence. Secondly, there's no evidence called. Secondly, there's nothing in the reservation in the 1969 head lease which would indicate impliedly or expressly that there were services. And thirdly, more importantly, and we do make the point, that if we're dealing with business common sense, the party's circumstance in 1974 would say, well, look, it's not immediately obvious that you need a right to go under Sheldrake Place East. There is a frontage to the highway, and that is the most logical place the parties might well have thought for any services to run. It's not as if it becomes becomes landlocked in that way. There is express reservations in the 1938 lease and the 1974 lease of equivalent rights for the landlord, and there is no such grant, and we submit that that's entirely deliberate, or must be deemed to be deliberate. But more importantly, as we've pointed out, I won't take you to it, but as at 1974, public utilities had statutory rights to run pipes, cables, wires, ducts, etc. under private roadways, and the parties may well have thought, well, that's sufficient. Each of the utilities that you might want in 1974 had rights to do that. And so why would you need it? If you can't get it in under the highway, well, then they can have a statutory right to put cables, wires, ducts, lanes, etc. to the boundary of Duchess of Bedford House. And the parties might well have thought, well, that's sufficient. And as pointed out, I think, those utilities, if they are installed, will belong to the utility companies. They won't belong, so they're not private rights, and there's no need for that. And we don't get there, but we would take the point, well, even if that is the case, even if it does exclude the right necessarily, tough. That's what you bargained for, and Lord Newburgh in Arnold, Britain, might say, that's unfortunate, but that's what the wording drives you. I don't say we get to that, because it's not necessarily an attractive submission, but we don't get there because you don't need it. But ultimately, we say that if the meaning of the clause is clear, however unfortunate the consequences might appear with hindsight, you don't do that. Can I just then deal briefly with my alternative submission that even if my learned friend is right, the words now subsisting don't encompass the right to park. We submit that the words now subsisting in this context mean now granted or enjoyed under the 1938 lease. That's all. That's what was intended to carve out. It is not intended to cover a right such as the right to park, which at that stage, if my learned friend is right and the judges are right, was a legal right reserved to the lessor, but not enjoyed as such by the various occupants of Duchess of Bedford House. Remember, as at the 1974 lease, Duchess of Bedford House there was a lease, a sublease, a sub-underlease, and they were all occupied by Rent Act protected, or mostly Rent Act protected tenants. So if the judge is right, and he made no express finding, but let's assume he is, that the right to park was being enjoyed by those occupants. They had no right to do so. They couldn't enforce that right at all. The landlord would have been able to say, no, get off, you're not entitled to it. It was a legal right reserved to the, under the 1969 head lease to the trustees. They didn't have to grant it, and we say that's the effect of the Carlisle laws. They wouldn't have. But if it was simply a practice enjoyed, and it's unlike Wright and McCallum. Wright and McCallum's a permissive enjoyment case. There was no evidence here that the lessee of the occupants of Duchess of Bedford House were permitted to do that, to do what they did. In fact, it's pleaded that they did. If you look at the particulars of the claim, it's a core bundle, page 264. This is paragraph 6 of the amended particulars claim. If you look at the you see it's expressly pleaded that they parked without permission.
So that's paragraph.
It's paragraph 6.
Thank you.
One that begins Sheldrake Place is a vehicular roadway, and it's 3 lines up from the bottom, the penultimate sentence.
Yep.
So unlike Wright and McCallum, where there was permitted use, which was turned by section 62 into this is a case where it's pleaded that they did so without permission. So we submit that in those circumstances, the practice of them doing it without permission, at most tolerated, cannot be a subsisting right. Subsisting means, even if you expand the dam, if you go back to the clause, if you talk about a liberty, privilege, easement, right, or advantage, that is not what is even on that wide description.
Which page are you at? For
I'm
your
sorry, I'm now
clause?
back at page 118, my lady.
Yep.
I'm back at it.
Yes, thank you.
I'm taking you to there which says that they plead it was without permission. So you've got
Yes,
a
yes.
non-permissive practice. And we say, when you refer to those now subsisting, it refers to actually enjoyed pursuant to the 38 lease. And in any event, even if you take a privilege, easement, right, or advantage whatsoever, the right to park as a non-permissive practice cannot be cannot fall within those, and is not a subsisting one. And it may well be, you see, that the words "except those subsisting" were inserted to preserve any rights under the 1938 lease, which weren't expressed or were not expressed in the 74 lease. And we say that's a perfectly clear, and that's the real meaning. It wasn't intended to encompass practices which were non-permissive. No evidence that the landlord ever knew about it, and were simply enjoyed as a matter of practice. That's not what subsisting is intended to mean. Therefore, even if Miller and Friends write and you can shift them to the end of the clause or the beginning of the clause, it doesn't cover the right to park. And it would cover, for example, any rights which arose under section 62 as a result of the 1938 lease. Take the pipes, if we get pipes, private pipes running under Sheldrake Place East as of the date of the 1938 head lease. Suppose they were there. The right to run those would arise under section 62. It would be a subsisting right, if unexpressed, under the 1938 head lease. That would be covered. But the right to park, which was not then a right, it wasn't enjoyed under the 1938 head lease. It was enjoyed by the sub lessees, occupants of Duchess of Bedford House, and is not covered by the word subsisting, and therefore some defendants, both judges, were wrong to find that it was.
Thank you very much indeed. Yes, Mr. Francis.
Something by way of clarification. First point, my learned friend took you to the office copy entries for Duchess of Bedford House leasehold estate, which is in the additional bundle, tab 3. This was earlier on, and he took you to the schedule of leases.
Yes.
For the purposes of suggesting that there was existing parking provision in 1974 within Duchess of Bedford House curtilage itself. And as a matter of correction, we know in 1957, and this is tab 6, tab 5 of the same bundle, that planning consent was granted for the erection of 3 garages on the northern part of Duchess of Bedford House, which prior to 1957 had been reserved potentially for dedication as a public highway. You can see that in the 1938 head lease. The land wasn't required for dedication as a public highway, and it's evident then that planning consent was sought and obtained for the erection of 3 garages on that land. And when you look within the additional bundle, tab 3, page 15, you can see on the plan, registered title plan, the 3 garages are in situ on the northern section. That, in fact, was the only parking provision there was within the curtilage of Duchess of Bedford House at the time of the 1974 head lease. In the schedule of notice of leases, there are 2 notices which relate to leases of 2 of those 3 garages. After that, within the schedule of notice of leases, the next entry, which refers to parking, is in 1982. And from 1982, there's reference to leases of parking spaces. Not before documents, not in the documents before this court, but in the documents before the first instance court, there was a number of documents which referred to the fact that in 1982, the head lessee of Duchess of Bedford House created parking spaces within the curtilage of Duchess of Bedford House, which it then sold to lessees of flats within Duchess of Bedford House at a price, causing some upset at the time because of the prices which were being charged. But that was in 1982. In 1974, the only provision was 3 garages shown.
Well, it's clearly that there's a dispute as between you about this. I mean, is this a matter we need to resolve? I mean,
well, my learned friend has said something which is...
I recall the evidence being that up at the rear of Duchess of Bedford House there was an access way prior to the 1982 lease has been used for general parking by residents of Duchess of Bedford House. The upset was caused by the fact that they then turned those, they divided it into parking bays and let them out at high cost. I think that was the evidence. That's the point. There were no designated. There was no net parking.
Well, for my part, I don't know about my lady and my lord. I don't think having an unseemly dispute between the pair of you about this during the course of this hearing is going to really determine the outcome of this appeal.
I'm entirely with you, but I do have to deal with the submissions.
Now, should we move on to your next point in reply?
The next point in reply, my learned friend referred within the 1974 head lease.
Yes, you want us to turn it up?
To clause 'to the exception which appears at page 2, page 117.
Where?
This is halfway down page 117. The exception of the right to building, notwithstanding that it may interfere with light or air to the demised premises. This form of clause is actually inserted for a specific purpose under section 3 of the Prescription Act to prevent the acquisition by prescription of rights to light in favour of the demised premises. This type of clause is construed in the authorities as a consent. As the lessor's consent or permission to what would otherwise be an acquisition of a enjoyment of light as a right, which would give rise to a prescriptive right in time under section 3. This is referred to expressly in Gale, paragraph 428, which unfortunately I don't have.
428.
428, and there are two authorities referred to, particularly OHJ Limited and FT Pattern Limited 2007 Chancery 341, which discusses this.
So your point is, this is a different circumstance. It doesn't shed any light on further clauses, and it's there in order for this to be a permission, so that you don't fall down the trap of prescription.
Yes, it's a conveyancing device, if you like. The next point, yes, my learned friend invited you to have regard to the contemporaneous objections which were made to the planning application and the appeal, some of which, albeit not all of which, but some of which have been extracted in the schedule to my learned friend's skeleton argument.
Yes.
The short point about this is that while it is right that some of the objections take issue specifically with the fact that the number of parking spaces will be reduced, a large number of them do not take objection specifically to that, but rather take objection to what I can classify as 3 different points. One is the visitor's point, which is that the parking scheme will prevent parking by visitors of people at Campden Hill Gate. The second is the pay point, which is that people have to pay for parking. And the third is the amenities point, which is that this type of scheme will damage the amenity in general of the square. And the pavements, planting, and gardens. So these scheduled comments, when you read through them, you can see that there are a few which complain about reduction in parking, but majority are in fact concerned with those other issues. Now, my learned friend spent some time discussing how one might envisage development of parts of Sheldrake Place which wouldn't in themselves interfere with the right of way, but would interfere with any right of parking, to make good the point that the right of way isn't the conclusive answer, which His Honour Judge Gerald thought it was. And one thing he mooted was the potential erection of gardens on the western side of Sheldrake Place East, in what would be the area presently occupied. One takes it by the gardens themselves and also the transformer station. The underleases of flats of Campden Hill Gate, again, haven't been included in this bundle, but within each of the underleases of, well, the sample underleases, which are before the courts below, of flats within Campden Hill Gate, one can see that flat owners have rights of enjoyment, access and enjoyment over the gardens, which would be interfered with by any development of the gardens. And that's something which His Honour Judge Gerald adverted to very briefly in paragraph 90 of his judgment, which I mentioned in my earlier submissions. My learned friend suggests that the erection of bollards in themselves, which restricted parking, would be an alteration within the contemplation of the second limb of the clause, which itself would be restricted by the rights of parking. That's something of a circular argument. First of all, restricting the use of any part of Sheldrake Place East for parking would, of course, amount to a substantial interference with any right to park, and therefore not be permitted if there is such a right. But that wouldn't mean that merely putting something on the land which restricted the ability to park would constitute an alteration, rebuilding, development, etc., of the demised premises falling within the second limb at all. Plainly, what is contemplated is something in the form of a substantial development, not simply the erection of bollards. Otherwise, one could say that doing anything on the anything which was proposed to be done on Sheldrake Place East would potentially catch the right of parking. Placing of skips would do so. And then my learned friend says, taking, or in answer to my commercial common sense point, relating to the transmission of utilities easements, sorry, in fact, in relation to the point that the first limb of the clause would be nugatory, if subsisting rights, if the exception of subsisting rights only applied to the first limb of the exclusion and not to the exclusion as at all. And he said, well, it's not difficult to think of examples where a right is transmitted, a utility right is transmitted under the first limb, which wouldn't then be caught by the second limb. And he gave the example of a private pipe connecting to the main sewer under Sheldrake Place East, which he said wouldn't be caught by the second limb because the existence of public infrastructure under Sheldrake Place East in any event would prevent any kind of development by way of underground parking. But again, that is on his own analysis. It's not difficult to think of developments which, although entirely theoretical, nevertheless, my learned friend says are ones which are legitimate to consider, which would be prevented by the existence of a private utility pipe running under only a part of Sheldrake Place East, but because it was limited in its geographical scope, didn't impinge on the public utilities infrastructure, and therefore was a kind of development which could take place notwithstanding the existence of the public utilities infrastructure. So it is quite easy to see that adopting the broad construction which my learned friend contends for, that existing private utility apparatus, the rights to use that would not be passed on because they would be caught by the second limb, even though the kinds of development which would catch them would be inherently unlikely and purely theoretical. Just a brief point about statutory powers. The point is made that in answer to the commercial common sense argument that the head lessee of Duchess of Bedford House wouldn't be too concerned about the non-transmission of utilities easements because it could always have resort, if necessary, to the statutory powers of the utility undertakers to provide the necessary infrastructure under the relevant statutory provisions which relate to each. The point about that is that undoubtedly there are statutory provisions in relation to electricity, gas, water supply, which first of all empower public utilities to lay mains, water mains, sewers, cables, etc., under private streets. There are also provisions which entitle the owners of frontages onto private streets to connect to those public utilities by the laying of private connections. So in that sense, it is correct that by one way or another, the absence of any private rights can be overcome, but not free of cost, the statutory powers which a private owner can call upon for the purposes of seeking to connect to public infrastructure are inferior to the private rights which that owner might otherwise expect to enjoy over existing utilities infrastructure. If there is an existing private water pipe, for instance, running from the mains serving Duchess of Bedford House, and that right wasn't passed to the head lessee of Duchess of Bedford House, and it said, well, that doesn't matter because you have the right to, this is under section 63 of the 1907 Metropolitan Water Boards Act, I think, you have the right to connect to the main sewer yourself, and you exercise that by notifying the water board and proceeding from there. But that's going to come at cost, laying a private connection, which is either undertaken by the frontager, in this case Duchess of Bedford House itself, or by the utility company, which will then pass on the cost to the private frontager. So the statutory powers which there may be are inferior because they come at a price and they come at inconvenience. So why on earth would one be content simply to rely upon those fallback statutory powers when there are existing utility rights which would otherwise pass by the 1974 head lease to the head lessee, but for the operation of this exclusion clause. And my final point, I may have misunderstood my learned friend's argument on this, for which I apologise if I have, but this is on the second question of construction, where he says, except those now subsisting, should be given a different construction from that which the judges below applied. And I may have misunderstood, as I said, but I understood him to be saying that the right to park, which was reserved by the 1969 head lease in favour of the lessors, the Fenimore estate, over Sheldrake Place East, was not a subsisting right within the meaning of that expression, or within the meaning of the words, except those now subsisting. And if he is saying that is simply wrong. It is a subsisting right, a pertinent to Duchess of Bedford House, because it's been acquired by virtue of the settled practice of residents of Duchess of Bedford House parking in Sheldrake Place East, which was converted into an easement by the reservation in the 1969 head lease in favour of the Fenimore estate. By virtue of that, a legal right, which is, in my submission, falls within the definition of a one which is now subsisting, was created by the 1969 head lease, and that was exactly what was within the contemplation of the words "except those now subsisting" in the 1974 exclusion clause. If my learned friend was saying something different, then he was wrong. If his point was simply that subsisting rights should be construed restrictively as applying only to rights which were subsisting in favour of the leasehold estate under the 1938 head lease of Duchess of Bedford House.
That I think is
I've
exactly
already dealt
what the submission was, and certainly that's my note.
Yeah, well, I apologise if I misunderstood it. I've already dealt with that in my main submissions, so I don't think I need to say anything more about that.
Well, thank you for clarifying that. Thank you very much. Well, might I thank all of you very much indeed for your submissions, both written and oral today, and for all those sitting behind who've assisted in the preparation of the case, whether bundles, writing, or general support. You won't be surprised to hear that we're going to reserve our judgments. I can't tell you precisely when we will be in a position to send a draft out, but we will endeavour to do that sooner rather than later. You'll receive in the normal way a draft. That's for the purposes of considering typographical errors and other infelicities, and it's not an opportunity to re-argue the case, please. Please draw attention to anyone that is interested at the provisions of the embargo, which appear on the top of the draft judgment. We expect a list, and it's applied very strictly to ensure that a draft judgment that's not ready to be handed down and is not perfected doesn't go to people who are not entitled to see it. I'm particularly conscious that so far as the residents are concerned, there's going to be a considerable anxiety to see what the Court of Appeal decide. But I just re-emphasise that the draft judgment is of no help to anyone if it subsequently then gets amended. So after that, I would hope that any other matters can be dealt with in writing.
My lady, is one, there is the respondent's notice. I doubt very much whether we have time today to
no, we do. I'm sorry, this case is not. No, this case will conclude today. There's no question of it going off to another day. I do apologise completely. So we've got an hour.
Okay, let me do that.
Now, of course, it's the second ground we're going to be dealing with.
Yeah.
That's what slipped my mind because we dealt with
No, I can see why we very much concentrated on that.
Can we turn then to the response?
Yeah. It's, again, a pure question of construction. We tend now to deal with the 1969 headings. And it's whether the words on page 98 of the Bible, except on reserve unto the lessors. 3. All other easements, quasi-easements and rights belonging to or joined by any adjoining premises. Now, the right to park as the practice, what is said is the practice of parking was at the date of the 1969 head lease, as we've said, an unpermitted practice on behalf.
Does it make any difference that it actually says but not objected to in the claim form?
Oh, it's tolerated.
No permission,
it's tolerated. It's, in other words, unlike, as we'll see, Newman and Jones, where it was permissive, this is just tolerated. The point is to plead. It's a similar sort of thing. Anyway, it can't be an easement because an easement is a legal right, and there was no legal right to park as at August 1969. It can't be a right because a right is something enforceable. So it has to be a quasi-easement if it's anything. And we've cited, and bear in mind the time, it's a pure question of construction as to whether the practice as found by the judge is sufficient to amount to a quasi-easement of the right to park as both judges held. And we've cited Pitt and Buxton, yes, which is and Great Western and Bailey. I'm going to deal with the points the other way round. I'm going to deal with the Newman and Jones point first, and then very briefly deal with it. It's not wouldn't have been regarded as an easement. First point to note is section 62 does not apply. It doesn't apply to reservations, and therefore it's a pure point of contractual construction. says whether it was a quasi-easement belonging to or enjoyed by or any adjoining or neighbouring premises. And the terms are narrower than section 62. And if one looks, for example, over the page at page 99, you see underneath the habendum to hold 95 years half, and then it says subject also to all rights and easements or reputed or quasi-easements appertaining to or any of the adjoining or neighbouring premises. Now, that's a wider clause because it refers to rights that are reputed or quasi-easements appertaining. But that doesn't apply here because it's not a reservation. So again, those that drafted the 1969 headings were aware of the terms of section 62, and they made the lease subject to, in other words, the lessor under 1969 couldn't have objected to any rights, easements, or reputed or quasi-easements appertaining to, but they weren't reserved to the landlord. All that was reserved to the landlord, and that's key because that's what translates a non-consensual practice into a legal easement, it's said, reserved, is the words in 98. All other easements, quasi-easements, and rights belonging to or enjoyed by any adjoining neighbouring premises. So, and it's important that. And a quasi-easement is a practice that would be an easement if by one group of people over a particular tract of land, if the two tracts of land were in different ownership. But that's not the case here. So the question is whether the right to park as found by the judge on the facts, as in August 69, constitutes a quasi-easement of the right to park. Now, you will have noted that what the judge said, he said various things, but what he didn't find was that every single occupant of every single flat, or occupants of every single flat in Duchess of Bedford House, parked their cars in Sheldrake Place East as at August 1969. He could not find that because there wasn't the evidence. But the right, he said, arose from that. Was that right? So the practice of people parking their cars, but certain residents, perhaps even a majority of residents of Duchess of Bedford House, parking their cars and the visitors, by reason of that phrase, was translated into a legal right for every single occupant of every single flat in Duchess of Bedford House to park an unlimited number of cars for an unlimited period in Sheldrake Place East. And he did that by reason the magic of Newman and Jones. And it's important we say, because it doesn't apply, that you look at that. It's a divider 18 of the authorities bundle.
Before we go there, what do you say was necessary, therefore? You would say, would you, I don't know, that evidence that each
Yes.
and every flat owner parked
Yes.
was necessary?
Yes. Normally when you convert an informal right, an informal behaviour into a legal right, the right that you derive from the informal behaviour is commensurate with the informal behaviour that preceded the granting of the right. And we'll see that's what happened in Newman and Jones. But what you can't do is say, well, maybe 30, 35, he didn't come to that. You have an impressionistic view that most of the residents who had a car parked there, and therefore the legal right reserved is every single one of them. But it says to derive from Newman and Jones, which is a first instance decision of Mr. Vice Chancellor Gary, and it's a divider 18. Now, there's three characters that you need to fixate upon here. First of all, at page 162, the second paragraph, the plaintiffs, Mr. and Mrs. Newman, are a married couple who hold a lease under an assignment date of the original lessees, Mr. and Mrs. Morris. So Mr. and Mrs. Morris, Mr. Morris was the original lessee. Mr. Marcus Jones, down at D, he's the defendant, he's the assignee of the reversion. Over at 163, letter C, Mr. Jones's predecessors in title were, of course, two limited companies, that I've mentioned, but a Mr. A.B. Brown, who gave evidence before me, was at all material times a director of both companies and in control of them, and he lived in one of the flats. So Mr. Brown was the original landlord and he lived in one of the flats. So both Mr. Morris, the original lessee, and Mr. Brown gave evidence. And then we go to, there's a long part of the judgment to deal with whether our conservatory is let, and he finds that there's no express grant of right. But he then goes on, can I ask you to look at, and read to yourself, and you may well have done it, but it's page 186 letter E to 188 letter E.
You want us to reread those?
Yes, I'd be grateful. I mean, if you've read it, I'll take you, I'll skip straight through it to points that I say are relevant. But, well, so he cites section 62.2, and you've already read that. And then he goes to G. The state of affairs of Mr. Morris's obtaining the grant of his lease was that he inquired about car parking from solicitors. He was told he could park anywhere. Now, that must have been from the landlord. So this is a permissive right, because we get both Mr. Morris saying, I was told by my solicitors I could park anywhere. He's the original lessee. So there's no other lessee, so we must have got the right from the landlord. Only when the proposed sighting of the roadway was carried out, we gave the car park mentioned in the lease. Mr. Morris said that he and all the other residents parked their cars outside their flats. Each tenant usually parked in the forecourt as near to his flat as he could get to his car. While he was there, no disputes about car parking arose. This evidence was not channeled in cross-examination. So the original tenant says all the tenants parked outside there as near as they could on the forecourt. Mr. Brown, this is the original landlord, too, testified that residents were allowed to park their cars near the entrance of the flats and that there was room for some 10 or 12 cars. From time to time, they would find that difference required. Some residents had no cars and usually enough room for those cars to park. So the evidence was either all the residents parked or 12 out of the 14 parked. There was no superabundance of evidence in the point, but it seems to me there's evidence enough to justify holding that at the time of the grant of the lease to Mr. and Mrs. Morris, there was a settled practice of tenants parking their cars on the forecourt. When the lease to Mr. and Mrs. Morris was granted 1st November, most of the other flats that were leased for 2 years or more, flat number 1, of course, been occupied by Mrs. Clark under her life tenancy until she died in 1973, and there's some testimony she did car, or she did the garage instead of being left on the forecourt windows. That is, however, does not seem to me to matter. The main question is what appertained or was reputed to appertain to flat number 1 when the lease was granted in November 1973. Now, those are the words of section 62.2. Did it appertain or was it reputed to appertain? In my opinion, where there is a block of flats and the tenants in general, emphasise those words, regularly park their cars within the curtilage of the block, the liberty, privilege, easement, right or advantage of being allowed to do this will rapidly become regarded as being something which appertains or is reputed to appertain to each of the flats in the block and as being reputed to be appurtenant to each of those flats. According to the grant of the lease on all flats, I think section 62 of the Royal Property Act will operate to give the lessees an easement of car parking appurtenant to his lease. I do not think that it matters whether the previous occupants of the particular flat did or did not park their cars in the curtilage block, or indeed whether they had any car. In all ordinary cases, the reputation would be that of a right of parking which goes with each of the flats. There will be no reason for one lessee to have greater rights than another in this respect. The question, can the tenants park their cars around the block, would receive a simple yes, and not an answer which distinguishes one flat and another on the basis of whether previous occupants of the question have been accustomed to park their cars around the block. I not, of course, say the rule applies to each and every block. And he goes on. And then there's the passage there, letter E, where he briefly says, and this is cited in all the way up to the Supreme Court, none of these points applies to person. In the view of Wright and McAdam, which was not cited, I feel no hesitation holding that a right for a landowner to park a car anywhere in the defined area is capable of existing, isn't it? That's the second point. But in respect of the first point, Newman-Jones has no application here. First of all, that was an application of section 62.2, and in particular, whether the right to park appertained or was reputed to appertain. Secondly, parking by tenants was permissive, and therefore it can be assumed that the landlord knew exactly what was going on. That's not the case here. Thirdly, no one other than the tenants parked their cars in the forecourt. There was no evidence that anyone did. Unlike here, where the evidence was that residents of Campden Hill Gate, and occasionally members of the public parked in Sheldrake Place East. And fourthly, the evidence was either that all the residents parked, or that the vast majority, 12 or so, parked. And on that basis, McGarry makes his finding. Now, this was a first instance decision which has never been tested in the Court of Appeal before, so far as I'm aware. It's been cited in a number of cases, but purely on the question of, there's one case where it's cited on a summary judgment point, and the other two cases, including Moncrief and Jemison in the Supreme Court, where it's cited as evidence that a right to park can be an easement. But it's never yet been decided, as His Honour Judge Gerald and the appeal judge did, to say that this is this applies in circumstances such as this. And in my submission, what has happened here is that His Honour Judge Gerald and the appeal judge have taken the words of Vice Chancellor McGarry out of context and used them effectively as a statute. And you can't do that. As I said, this is not a Section 62 case. There is no possibility. There's nothing to do with. It doesn't matter whether the right is reputed or appertains. It is your question is whether it is a quasi-easement enjoyed by any adjoining or neighbouring premises. And the key from in Vice Chancellor McGarry's judgment was reputed. Look, if all the residents, or most of the residents, park solely in the block, the right appertains or is reputed to appertain. But that doesn't apply here. As I've said, normally if you want to derive a legal right, because that's what this is, a legal right for someone to park, it has to be commensurate with the practice that is that has been found to occur. The reserved right has to actually have been enjoyed in that way. And secondly, I say, the reference in Newman and Jones to tenants in general means all of the tenants, because that is the legal right. That's the evidence that McGarry heard, and in this context, that's what it means. Because, say, if you want to derive a legal right, a very wide-ranging legal right, you have to have behaviour commensurate with that. Now, if you look at what His Honour Judge Gerald actually found, he comes nowhere near to that. One, both he and the judge effectively say, well, the right to park is reputed to appertain. So that's what they apply when this is not a Section 62 case. And secondly, they countenance the right to being accorded to every single flat from behaviours that are much less than that. And you look at paragraph 25 of Gerald's judgment, is on 2243. He asks, what is the right question? The central question there was whether on left those and say for a reasonable time for the residents of Duchess of Bedford House as a whole use Sheldrake Place to park their vehicles, not of the visitors. That's the right test. If he means every single one of them, yes, that's the right test. But that's not the test he then applies. If you go to paragraph 27, he then says, however, my judgment is sufficient evidence to reach the ground conclusion justified in time of the reservation, settled facts of residents of Duchess of Bedford House who have vehicles and their visitors park in Sheldrake Place. It's not the test at all. It's not all the residents, it's only those who have vehicles. Now, we don't know the evidence of Mr. Walmart was that most of them had. But most is not good enough. And then if you go to paragraph 37, he says this. It's of course not possible to determine which residents guests parked vehicles were. The reasons I've already stated, it seems to be more likely than not the vast majority would have been residents or visitors of Duchess of Bedford House. That's the vast majority of those parking. Possible for that some members of the public. There's some evidence that occasionally members of the public did park there, but that's not seem particularly likely, particularly further when you get to the walk. It's common ground Sheldrake Place can be now accommodated there, back in that particular accommodate 220-22 parked vehicles. Paragraph 40, the last sentence. it certainly points in the direction of there being a regular pattern of parking at a time Duchess of Bedford House residents and their visitors on Sheldrake Place. Otherwise, we're talking, why would the cars be right outside the entrances? Paragraph 43, never accept her evidence. This is Lobados, parents and sister. From then on, right up to the day of resident afterwards, those residents who owned a car within her block would park in Sheldrake Place. And then it goes on. 46. And it's not necessary for me to determine whether each and every one of those residents, those named individuals are residents, not only because they would be impossible somehow in the task, but the central cost of evidence was credible, rather namely there was a substantial number, around 10 to 15 people, residents who had a car in her block and parked in Sheldrake Place. Well, the judge overturned that rightly because the evidence was it was only 7 or 8 in her block. But the point is, he then takes some people in the block and expands it. And that's paragraph 141, paragraph 38 of the appeal judgment. The judge overturns that finding. It says it will refer that wrong. And he says at 48, for reasons already stated, that does not cause me to be concerned as to her reliable credibility. It's also my judgment leads, and this is the case, led the defendant down a somewhat dangerous path, focusing too much on precise numbers and using that as a way of undermining your chance of overall validity of the claim. Of course, important as a significant substantial using, but trying to cherry pick or salami slice people in various ways undermining the credibility of particular case. So you've got that wrong. It's not a case of whether it reputes or whether it appertains, it's whether there's an actual quasi-easement. And in order to derive that, the right is derived, every single one has to park.
Well, I'm sorry, I don't want to interrupt because I know how pressed for time we are.
Yeah.
But I'm afraid I just don't see how that ties in with on page 98 of Newman and Jones at G.
Yes?
Where the judge said, and it might be thought that McGarry knew a thing or two about land law.
Yeah.
I do not think it matters whether the previous occupants of the particular flat did or did not park their cars within the curtilage block, or indeed whether they had a car. In all ordinary cases, the reputation will be that of the right of parking, which goes with each of the flats.
Yes, 2 points. One, the evidence wasn't all did, or most did, or vast did, 12.
The point is that the reputation
Yes, but
went with the right.
that's right, but
park.
that's section 62. That's not here. That, if you look at the wording of section 62, that's what he applied. And that's what led the courts below into error.
I see. Very well.
Because
Do
what
carry
they're-
on. No,
Well,
do carry on.
what they're saying is because a percentage, perhaps more than 50% of the residents parked in 1969, there was a reputation of a right to park, and therefore that became a quasi-easement. If this is a section 62 case, I could understand that. You could say yes, McGarry. You could apply McGarry if there was a reputation. If you stand there and look, there's a right to park with that. That's fine, but that's not what. This is a contractual construction point, and it's under section 90. It's under the 1969 headings. And if the fact that even the majority of residents of Duchess of Bedford House were in the habit of parking their cars on Sheldrake Place East did not render that a quasi-easement for every single one of them to park there. It's not a case of reputed appertain. That's what McGarry said, and I understand.
Well, please could, first of all, I'd be grateful if you didn't call Vice Chancellor McGarry just McGarry.
Oh, I'm sorry.
And secondly, and more importantly, please can I be clear and certain in my mind how you define a quasi-easement and precisely what you say would have been necessary.
Yes.
So that I can write them down.
Yes. Well, a quasi-easement, I suppose, an easement is a right, legal right granted by one landowner over his or her land in favour of the owners or occupants of another. A quasi-easement is a right which would be an easement, indeed may arise over land which is in separate occupation, but which is joint, is in a single ownership. And the important point is that the easement of a right to park is said, the right to park as found by the judge, is a right for every single resident of every single flat in Duchess of Bedford House to park an unlimited number of cars. Under the correct construction of this clause in the 1969 head lease, in order for that right to be reserved, the behaviour, the pre-reservation behaviour, had to be commensurate with the right. That is, every single one of the residents had to park.
And that's a real issue.
That's right. I'm sorry, I no way intend to be rude to Vice Chancellor McGarry.
So, as we discussed a few minutes ago, you were saying, therefore, there would have had to have been evidence that, as a matter of course, or however one puts it, over a substantial period, each owner of each flat had parked and their visitors had parked.
Yes, because that's how one normally derives a legal right by prescription or by previous behaviour. That's how the behaviour has to be commensurate with the right grant. Now, the way Vice Chancellor McGarry was able to do it in that case, he found either, well, he didn't make a finding, but there was either the evidence was every single resident had parked, or 12 out of the 14 had. But he applied section 62, I've said, which is appertained or reputed to appertain. That's the key finding. So it didn't matter that it might occasionally have been the fact one or two flats didn't park. The fact was, did the right, if you looked at it, standing objectively as at the grant of Mr. Morris's lease in 1973, would one have thought that the right to park within that curtilage were attached to every single flat? And that was on the evidence, yes, he found, because the evidence was either that all the residents or the vast majority of residents and no one else parked.
Where does he say no one else?
Well,
I just don't remember reading that.
You've got the evidence, that's the evidence.
No.
You've recited it. It's on the exiguous evidence. Well,
No, I'm talking. I thought maybe I misunderstood your submission. In which case, I'm glad I asked the question. I thought you were saying that part of Newman and Jones was that there was no one else. That is what you were saying.
Yes,
And if you just show me where in the judgment that's there, that would be great, because I missed it.
There was no evidence that anybody else parked.
That's, as you know, not the same thing.
Well, if the state of affairs, he summarises the evidence at 97G to 98B. That's
Right.
Now, and he says there, all the rest parked their cars. Each tenant usually parked on the forecourt nearest flats to get. While he was there, no disputes. Mr. Brown, too, testified that residents were allowed to park their cars near the flats, and there was room for some 10 or 12 cars. From time to time, there were minor difficulties about parking and so on. So,
Keep going.
there was no superabundance of
No,
evidence on the point.
but some residents have no cars.
Yes, but there was 12. That's why there was no problem, because some residents had no cars and there were 10 or 12 parking spaces. I think you're entitled to conclude from that there was no evidence anybody else parked there. If Mr. Brown is saying there's not enough room for 14 cars, there's room for 10 or 12. That's the point. I mean, it's the difficulty in extrapolating Newman and Jones, because it's a first instance decision where the defendant wasn't represented and was clearly taking some bad points, and there wasn't a superabundance of evidence upon which the Vice Chancellor concluded that there was a right to park, but he did. And you've seen it, that's the judgment. My point is that it's an application of section 62.2, which doesn't apply here. And the evidence is completely different here. I've summarised it. And when he says, even if you can apply the reputation, when he says tenants in general, that is, it must be read, it's not a statutory phrase. It's a phrase of the judgment. And when he says that, he means all the tenants. that's that point.
Does that conclude your submissions on the
It doesn't.
respondents?
I don't leave the other point. The other point is that a right to park wouldn't have been regarded as an easement in 1969. There's we made that point, that there is one case called Birss, but I just make 2 points. First of all, if you look at the case of London and Blenheim Estates,
Yes.
which is divider 20, page 199. Now that's some 22 years after the grant of the 1969 head lease. If you look at, slightly seeking the pants point, but if you look at paragraph at page 200, if you look at the advocates for the defendants, future Mr. Justice Lightman and the future Lord Briggs, and they felt able to argue in 1992 that the right to park couldn't be an easement. They lost after consideration, and I urge one you to read the lined paragraphs there, because there's a serious argument there in 1992, some 2 years later, as to whether a right to park could be an easement. There is no mention of a right to park as an easement in the relevant edition of Gaylord easements, so we've cited you that. It doesn't arise till some 2 editions further. And then, if you go to Moncrief and Jensen, which of course is the House of Lords case, on the point, there is again, some years later, an argument about whether a right to park can be an easement. Now, there is a case called Duchess, which is a very briefly reported High Court decision, which you will see is 1968. That's Divider 16. That's a judgment of Mr. Justice Buckley. And he says there a right to park could be an easement. That decision wasn't cited in Gale for some edition for some years. But that's a very different fact. That was a question about whether the express grant of what's known as a general car parking facilities within a defined area was an easement. And there, the evidence, if you read the brief report, the evidence is that it was an exclusive right to park cars within a defined area. And my point is a simple one. The right to park, as found by the judges here, is, as I've said, a right for an unlimited number of people to park an unlimited number of cars for an unlimited period. It would simply not have been regarded as an easement in 1969, and it's a question of contractual construction. What was reserved in 1969 and re-granted, so my learned friend says, in 1974. This lease is not an ever-speaking document, it's not like a statute, so you have to construe it as at 1969, and as at 1969, the parties reasonably circumstanced would simply not have regarded the right to park as found by the judge as an easement. Therefore, it couldn't have been exact. Those are my submissions.
Yes.
If I can first deal with Newman and Jones. The facts of Newman and Jones are not quite as my learned friend has set them out. In Newman and Jones, the question before the court was whether, on the grant to Mr. Newman's predecessor in title to flat 1, that was Mr. and Mrs. Morris, on the 1st of November 1973, of a lease of that flat, there went with the lease of that flat a right to park in the forecourt of the block. And that depended upon establishing the factual position in the period prior to the grant of that lease to Mr. and Mrs. Morris. In other words, the factual position in the 2 or so years or more before that. The evidence that period is as follows. My learned friend refers, first of all, to the evidence of Mr. Morris relating to parking. The evidence of Mr. Morris relating to parking in the period after the grant of the lease to him on the 1st of November 1973 was irrelevant. One was looking at the position in relation to parking before the grant of the lease to Mr. Morris. So Mr. Morris's evidence was irrelevant. Page 187, the evidence of Mr. Brown, the landlord, was that residents were allowed to park their cars near entrances to their flats, but there was room for 10 to 12 cars. From time to time, there were minor difficulties about parking. And then the point picked up by my lady, Lady Justice King, the words, but some residents had no cars. And there were usually enough rooms for tenants with cars. So the evidence of the landlord was that in the crucial period, the parking which took place by residents of flats within the block was not universal to all the residents of all the flats, because some of the tenants, didn't have cars at all. And then in relation to flat 1, the flat for which Mr. Morris was granted the lease, the evidence in relation to that flat was previously occupied by Mrs. Clark, as we see in the middle paragraph at page 187. It had been occupied by Mrs. Clark under a life tenancy until she died in April 1973. That is 7 months before the grant of the lease to Mr. and Mrs. Morris. And there is some question whether she had a car, or if she did, whether it was not kept in a garage instead of being left on the forecourt. That, however, does not seem to me to matter much. The main question is what appertainer was reputed to appertain to flat number 1 when the lease was granted in November 1973. So, when the lease was granted to flat 1 in 1973, what was the evidence of parking in the period prior thereto? It was that residents of the block who had cars, but not all did have cars, parked. And that didn't include, or there was no evidence that Mrs. Clark, while she was there until her death in April, either had a car or she did parked at all, because she had parking elsewhere. So far from the evidence upon which Mr. Vice Chancellor McGarry made his findings being one under which all or almost all of the tenants had a settled practice of parking in the curtilage of the block, the evidence was far less pervasive than that in terms of the practice of parking. It was a practice which the evidence revealed was enjoyed only by some of the residents, those who had cars, not including Mrs. Clark. So my learned friend cannot say that the judges below misapplied Newman and Jones because on the facts of Newman and Jones, all or almost all of the tenants had a settled practice of parking. That's not what the evidence establishes at all when you read the judgment. And I'm afraid there's been a conflation of the evidence of what happened before the grant of the lease to Mr. Morris with what happened after. Mr. Morris's evidence, which my own friend relied upon, relates to the period after the grant of the lease, so it's irrelevant. So that's the first point, that the basis of the finding in Newman and Jones as to the existence of a right which is reputed to appertain to the blockers as a whole was not based upon evidence of parking by all or almost all of the tenants within the block. And so that is not a ground on which my learned friend can properly say that Newman Jones was misapplied. The next point my learned friend says about Newman Jones is that Newman Jones was concerned with the grant of a right of parking in connection with an individual flat under Section 2 on the grant of a lease of that flat, and therefore you can't extrapolate from the reasoning of that case to the facts of this case, where we are concerned with the reservation of all other easements, quasi-easements and rights belonging to or enjoyed with the demised premises. To the extent my learned friend suggests that there is any relevant distinction between the operation of Section 62 and the operation of the express reservation in this case, based upon a difference in language between Section 62 on the one hand and the express reservation on the other hand, that is a distinction without a difference and provides no principal basis for saying that Newman Jones would not apply. What was reserved under the 1969 head lease, as I've said, was all other easements, quasi-easements and rights belonging to or enjoyed with demised premises. And those words are important. My learned friend says this would only be reserved by the 1969 head lease if it was a quasi-easement. That is not what we submitted below, and it is not what the judges found below. The judges found below that this was reserved, the right of parking was reserved because it was a de facto right enjoyed as a settled practice by residents of Duchess of Bedford House. A de facto right falls within the words rights enjoyed with the demised premises. There was no real debate below about whether it was a quasi-easement at all, because the case was based upon it being a de facto right. And the fact that a de facto right can fall within the ambit of the clause rights enjoyed with the demised premises is one which itself is clearly established in the authorities by the case of Bailey and Great Western Railway as long ago as 1888. We have the benefit of judgments from Mr. Justice Chitty and then 3 Lord Justices, so you can take your pick. I would ask you to read the judgment of Lord Justice Fry, beginning at page 84 and 1/3 of the way down 85, as the most succinct of the passages.
Page 85 is sidelined, isn't it?
Yes, yes. You don't need to read the whole of it, though. It's really actually in the up to the end of the first paragraph. To similar effect, and I won't invite you to spend time now reading this, but the judgment of Lord Justice Bowen, which the analysis begins at page 81, but the crux of the analysis, if you like, is at page 83, which begins. It is still, I think, a question of construction, and he then explains how rights which are enjoyed de facto only are caught within the clause in question, which reserves rights enjoyed with or pertinent to the land. So he expressly says that that language is apt to encompass what are described as de facto rights, which is exactly what the judges below found existed in this case. That is a settled practice by the residents of Duchess of Bedford House to park within Sheldrake Place East, which amounted to a de facto right, de facto because it was something enjoyed not pursuant to a legal grant, but as if a right, in the same way as if it were a legal grant. And also Lord Justice Cotton, similarly at page beg your pardon. At page 448 to 449 of the judgment. So, sorry, where did that get me? Yeah, the point is simply that the 1969 reservation of rights enjoyed with land was one which was apt to capture de facto rights, such as those enjoyed by residents, for the purposes of establishing that those de facto rights were ones which were not limited to the individual flats within the block, but applied to the block as a whole. Newman and Jones establishes that what is required is that there is a practice by tenants in general, as Vice-Chancellor McGarry described it, of parking. The practice of tenants in general is not the same as a practice of parking by all or almost all the tenants. And that is clear because the evidence in Newman and Jones itself didn't establish anything like that. It is said that the judges below in this case misapplied Newman and Jones because the evidence upon which a right appertaining to the block as a whole was established was the evidence not of enjoyment of parking by all or almost all of the flats, but only by a substantial number of residents of the flats. And that is said to be a misapplication of Newman and Jones. That submission, I say, is untenable when you look at the facts of Newman and Jones itself. And indeed, when one takes a step back and asks oneself what type of practice, what type of user would you consider was sufficient to give rise to the reputation which applied to a block as a whole? I mean, just take another example. For instance, you have a block of flats, 100 flats in a block. The tenants, all of them have rights of way over the main roads, over the main paths leading to the block from the public highway, which are owned by the landlord. But round the back of the block, there is another path, which is a shortcut to a local shop, over which there's no express grant of any right of way under any of the leases granted any of those 100 flats. And say, for example, as one might expect, residents of flats within the block, an unspecified number, but a substantial number all the same, get into the habit of using the shortcut across this path over which there's no express right of way. Would it make a difference when you're asking to whom does the de facto right of the use of this path apply? Would it make it? Would you insist upon the right applying only to the residents of the actual flats who made use of the path in question, or would there come a point at which the practice was so widespread that you would say that it was one which applied to the block as a whole? As a matter of common sense, once this path is being used by a substantial number of residents of flats, you say, well, this is a right which appertains to the block as a whole. And it's exactly the same with the right of parking. And what you wouldn't expect to do is to say, oh, well, that person is the resident of flat 55, and therefore we could say it's a right which appertains to flat 55, and that resident, she's in flat 70, so we can say it's a right which appertains to flat 70, and so on and so forth. But it's not a right which appertains to the block as a whole, but rather just to these individuals. That, in my submission, might be the case if it were a handful of residents, but when it is a user by tenants in general, in other words, a substantial number of tenants within the block, then it is a right which appertains, is known as applying to the block as a whole. And that makes perfect common sense. It's exactly what Vice-Chancellor McGarry found in Newman and Jones, and there's no reason whatsoever to doubt the correctness of that decision. It has since been applied, albeit not in the context of a final decision, but in the context of an application for interim injunctive relief in Handel and St Stephen's Close. And is, of course, cited in Gale for the proposition upon which we rely. So there's no reason at all for saying that it isn't equally of application to the present case. The other point, which my learned friend relies upon in his respondent's notice.
Before you go on,
yes.
On Newman and Jones, I think something else that the point which was made was actually it was different there from here because there it was consensual parking outside the block in Torquay or wherever it was, whereas here it's not consensual. I think something like that was said. Do you?
I really don't understand the principal basis for making that distinction. We know that under Section 62, rights can be created based upon what was previously a permissive user, as well as based upon a user which was not permissive. It's the fact of the user and the fact that the user is more than simply incidental. It's a settled practice in the period prior to the conveyance in question, which gives rise to the statutory magic of converting it into a right. Whether it's permissive or not makes absolutely no difference whatsoever. to that analysis.
And it doesn't make any difference, you would say, in relation to those wider words in the reservation?
No, because the reservation reserves easements, quasi-easements,
Rights.
and rights belonging to
Mm-hmm.
or enjoyed with. So rights enjoyed with refers to de facto rights. That takes us back to GWR and Bailey, where a de facto right is one which is, well, that's what we can see from the facts of Bailey itself, where land is in common ownership, and there is a way from one part of the land to the other, which is used for the purposes of accessing that part of the land. When there is a conveyance of that part of the land, there goes with it the de facto rights which were enjoyed with it. That happens in GWR and Bailey, where you have an express provision which carries with the conveyance rights enjoyed with the land. In any event, it happens under section 62, which mirrors what may otherwise be contained within an express provision. It's absolutely right to say, of course, in cases of reservations, section 62 is of no application, it only applies to grants. But we're not relying upon section 62 for this part of the argument. We say that the reservation itself is clearly wide enough as a matter of its proper construction, and so both judges found below, to encompass de facto rights, that is, user enjoyed as a settled practice, in conjunction with the demised premises, sorry, over the demised premises, in conjunction with the adjoining land of the lessor. So I think that answers your ladyship's question.
You were going on to the other point.
Yes, yes. I'll be as quick as I can, given the time.
We really, I'm afraid I can't sit past a couple of minutes after 4:30.
No.
Well, we have, of course, got everyone's written material.
But I don't think, with respect to my friend, that this is a point which, the point which is pressed most strongly upon you as the basis for overturning the decision of the judges below in relation to the reservation of the right. His submission is that, as a matter of construction of the 1969 reservation, it wouldn't have been understood as applying to rights of parking because it wasn't recognised that rights of parking could exist in 1969.
It would have been an easement in 1969, was what he said.
Yes, well, first of all, if you describe it as an easement or a right, it doesn't make a difference because the 1969 reservation is of all other easements, quasi-easements and rights. Secondly, you need only read the erudite, if I can respectfully so describe it, judgment of His Honour Judge Paul Baker QC in London and Blenheim Estates.
Well, I think we've been referred. I think we're conscious we're all going to have to go away and read that in detail.
But you only need to read his historical analysis to see that rights of parking were recognised in 1969. They were recognised in not just Bilkus, but also in another case which he refers to, and also in a case which I referred to in my skeleton argument, which is the Sweeten Maxwell case, reported in 1966. But more importantly, perhaps, the the analysis of the judge shows that even before those cases in the 1960s, there was a recognised class of easements based upon storage of material, where the relevant question was not whether storage could exist as an easement, it could, but rather whether storage was such that it prevented any other beneficial user of the servient land. And cases where rights of parking in Copeland and Greenhalgh were found not to be established were not because right of parking was inherently incapable of being the subject matter of a grant, but rather because the right, as it was claimed in Copeland and Greenhalgh, amounted to beneficial use and enjoyment of the servient land as a whole, which was considered to be too broad because it excluded the servient owner from any beneficial user of the servient land, him or herself. And as you'll see from Judge Paul Baker's analysis, Copeland and Greenhalgh sat somewhat odds with Rice and McAdam. He sought to marry the two cases by a coherent single doctrine, which is the doctrine of ouster, which says that if a right is so broad as to oust the servient owner from any beneficial use of his land, then it's too broad to exist as an easement. That, in my submission, probably reflected the law as it was understood in 1969. Since that time, and since His Honour Judge Paul Baker's judgment, Moncrieff and Jameson has moved matters forward, as Lord Scott in Moncrieff and Jameson has now doubted the ouster principle as the correct analysis at all. And that's paragraph 57 to 61 of Moncrieff and Jameson, which I don't have time to take you to now, but it doesn't really matter. The point is, in 1969, rights to parking were recognised as something capable of being the subject matter of the grant. The only question was whether the right was too, the writer's claim may be too broad because it contravened the ouster principle. And on that, in this case, my learned friend suggests that what we are claiming as a right, his submission in the courts below was that what we were claiming as a right was too broad. But that was based upon a misunderstanding or mischaracterization of the right as it is claimed. Because what is not claimed in this case is a right to park on Sheldrake Place to the exclusion of others, including the servient owner and others enjoying a similar right.
It's in competition.
It's in competition. This exact same point was taken in Newman and Jones, and Vice-Chancellor McGarry dismissed it as being groundless for the same reason, that what was being claimed was not an exclusive right, but rather a right to park in competition with others. That kind of right, by definition, doesn't exclude any reasonable beneficial user of the servient land by the owner of the servient land, because the servient owner itself can use the land for parking in competition with the dominant owner. So,
Now, Mr. Francis, I think we've got your submissions on that, and we know where you're going and we know where to read. So I think it's only fair that we give 5 minutes to reply.
Of
But
course.
thank you very much.
I hope I don't need it. I'll come back just briefly on the de facto right point. It's nonsense. There's no such thing as a de facto right. If you look at, again, paragraph 99 of the Bible.
Sorry, paragraph 99.
Paragraph 99. It's the 1969 Henry's, and it's the page after it's page 3 of the 1969 Henry's, page 99. It's a clause I've objected before. But it's a subject also to all rights and easements, or reputed or quasi-easements appertaining to any of the adjoining area. So that's a wider right. Those are words there, but that's not the relevant clause. So if they wanted to refer to reputed rights or appertaining to, the parties could and did do so. But the relevant clause, which is back to page 98, it reserves all other easements of quasi-easements and rights belonging to or enjoyed by any adjoining or neighbouring premises. Now, the word right, in my submission there, is intended to mean something you have a contractually enforceable right to. So right is a right. It's something you can enforce. That was not what practice of parking was in 1969, whoever was doing it. And if you look at Bailey and Great Western, it actually makes my point for me, because it makes the point that it's all a question of construction. Can I again briefly take you to that? It's the authorities bundle, divider 9. I'll start at page 80. And that's the judgment of Lord Justice Bowen. And no doubt you'll read this, the lined passage, but he says about 6 lines down the line past the sentence. First, as to the terms of the conveyance, I think this is a pure case of construction of the conveyance. So that's what they were doing, and that's what you are doing here. And if you go over to page 82 of the bundle, page 453, he sets out the words. And I'm going to read from just towards the end of the lined passage, page 453, page 81. He says this: here we have express words, and what we have to decide is whether this, in a way, is a way which the owner, by appropriate language, has shown an intention to grant. Now, recall, this was a path to some stables. The stables were conveyed. The path, or the way which had been used by the occupier of the stables, was not conveyed. And it was a question of whether the general words in the conveyance operated to convey a right of way to the stables. So very different from there. And it wasn't a case of Section 62. It wasn't a case that the right granted was not commensurate with the practice that led to it, the behaviour led to it. But as to the fact that the owner has granted the stable, this is a hard-beaten road which has been the only way by which access to the stables can be had. There were doors to the stable leading onto the field and not facing to the road itself. But this road to AMB has really been the path to the stables. Let's see what the grantor said. He said he grants the premises, including the stables, quote, together the buildings, erections, sheds, walls, heads, fences, trees, ditches, rights, members, and appurtenances whatsoever, the several pieces of parcel land, and arithmets hereby granted, or otherwise assured or intended to be so, or any of them belonging or in any wise appertaining, or deemed, taken, or known, held, occupied, enjoyed as part of the whole. Now, it was entirely unsurprising, given the wide words used in that case, and the facts of that case, that a right of way over the beaten path was said to be conveyed or reserved by that. And with respect, that's very different from here. And I would urge you again to look at the judgment of Lord Justice Fry at pages 84 and 85, where again he says it's all a question of construction. And if you look at the facts here and the words here, the right of way is reserved. So what you have to do is construe the words easements, quasi-easements, and rights belonging to or enjoyed by any adjoining or neighbouring premises. And in my submission, the right to park is not an easement, because it wasn't an existing easement. It's not a right. They had no enforceable right to do what they were doing. If anything, it's a quasi-easement. And my submission remains that we need a practice commensurate with the right to do it.
Thank you. Anything else?
Sorry for taking your time.
No, not at all. It's just unfortunate I have to be somewhere else quite shortly. Well, thank you all very much indeed. I've said it all once before. I won't say it again. We're still reserving our judgments, and we will hope to have